Good evening. Thank you all for attending today's special board meeting of the Santa Rosa City Schools Board. Opening this meeting Wednesday, February 15th, 2023. And before we begin, I'd like to just do a land acknowledgement, as is our practice with our board meetings. Santa Rosa City Schools acknowledges that the ground beneath our feet is historically the home of Indigenous peoples, many of whom have been forced to leave their lands. We sit on the traditional homelands of the people of Coast Miwok, Southern Pomo, and Wapo. We honor them and other Indigenous caretakers of these lands and waters, and remember that Indigenous peoples are not a people of the past, but are here with us now. Join me all with the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We will now open the meeting up for public comment on agenda items only. Speakers are limited to 3 minutes each. Do we have any blue cards this evening?
Manieri, there are no blue cards.
Okay, we will move on to our virtual attendees.
There are members of the public joining us on Zoom and would like to comment on the agenda item only. Please raise your hand. There are no hands raised.
Thank you. We will move on to item B1. This is our board governance training. The Board of Education will receive training as a governance team on student discipline and expulsions, AB 2449, and general governance practices. And I will hand this over to Superintendent Trudeau.
Thank you so much, President Manieri, members of the board, those who are with us in person and online. Thank you for your time this evening, that we bring forward topics of conversation that are important for us to engage in a study session, such as our student discipline and expulsion practices, specifically through the lens of your work as a board. Also new information about AB 2449, which will be replacing AB 361 and some other general governance practices. And I would like to welcome from our legal team, and they can certainly introduce themselves when they speak, Namita Brown and David Mishuk. Thank you so much for joining us this evening. And with that, I'm actually going to hand it over to, I think, David, who is going to start us out tonight.
Oh, okay, now I'm on. Hi. Thank you everyone for having me again. I'm David Mishuk. I'm here with my colleague Namita Brown, who's going to introduce herself probably a third time when it's her turn. But thank you so much for having us here. And I'm going to do a presentation for you, a training on student discipline. I'm going to invite the board at any point to stop me if you have any specific questions. I want this to be as interactive and as much of a learning experience as possible. Now, I'm going to see if I can share my screen. Give me a second. There we go. All right, so now there we go. So we have a few aims of the training that I want to present to you today. You know, one is sort of the dry clarifying the legal obligations and limitations for student discipline. But why do we do that? And we do that because the aim of this district, the purpose of this district, of this board, is to educate students. And part of educating students is to protect their rights to an education. So we're going to discuss some best practices. And the hope of this presentation at the end is that we're going to foster uniformity in how discipline is how discipline occurs in this district, and also promote equity amongst your students. Now I'm going to sort of launch right into it. There are very specific grounds for suspension and expulsion in the state of California. I'm not going to belabor each one of these, but this is the first part of the list, and this tracks Education Code Section 48900. It starts with A, and I think it goes through L, but we will see. It actually goes through T. And as you can see, there's very specific acts that a school district could suspend or expel for. Now, in addition to 48900, there's some additional statutes, 48900.2, 0.3, 0.4, and 0.7 that deal with later added acts: sexual harassment, participation in hate violence, harassment, threats, or intimidation, and terroristic threats. Now, I want to start with suspension. Now, with suspension for any of these acts, there are limitations placed on school sites, and those limitations can be found in 48900.5. What 48900.5 is trying to instruct our school sites to do is to use what are called other means of correction. This term is going to come up later in expulsion, but it's actually sort of important to keep in mind here because 48900.5 defines some of those other means of corrections. Those can include counseling services, an SST or a cost referral, special education assessment, restorative justice, positive behavioral services, after school community service. Now, there's exceptions to this. Those exceptions are the A, B, C, D, or E offense. And if we think back to that first slide with all the lists of offenses, those are the first 5 offenses that are listed. Or if there's a determination the pupil's presence on the school campus causes a danger to persons. There's also some limitations on suspensions. The first is that suspension can only be up to 5 consecutive days. And one of the things that when I do these trainings for school staff, I like to pose is what are the standards that are being used for deciding whether a suspension is a single day, 2 days, 3 days, or 5 days. The last time I actually did one of these trainings, I posed to staff that in my experience, I've never seen a 4-day suspension. It's usually 1 day, 2 day, 3 day, and somehow we just jump to 5 days. But what are the standards that we're using in terms of the length of suspension? And then also there's 20 days total. And one of the challenges I give to school site staff that I'll pose to you as well is when you get up to a 20 days of suspension during a school year, what has not been considered for this particular student? There's also practical limitations to suspensions. Now, these aren't found in the education code, but really more found in common sense. The age of the student. What is the aim of the suspension? What is the underlying issue we're trying to solve? Does keeping a student away from school for a day really address the underlying behavior, the motivation behind that behavior? And then lastly is disability. That's both a legal and practical consideration. No, I'll get back to it a little later. Now, when we talk expulsion, we have 5 what are called mandatory expulsions. I'm not going to talk through these, but what I'm going to say is that these expulsions are both required in terms of a recommendation by school site staff and also a requirement of this board or any board to expel the student if it is found that they commit one of these offenses. There's a second category, which is a mandatory recommendation unless inappropriate. That includes causing serious bodily injury and possession of a knife, explosive, or other dangerous object that's not of any use to the student. It also includes possession of a controlled substance, robbery or extortion, assault or battery. And for all of these, what are called supportive findings are required. Now, I realize that I forgot to mention something. Of the 5 mandatory expulsions, one of those can cause sometimes issues. And when I say issues, I mean issues of consideration, of determination, of equity. And that single one, I think, is dealing of a controlled substance. And why is that? Because under California law and federal law, marijuana remains a controlled substance, but it is legal for adults in this state to possess and use. And a student dealing marijuana or marijuana products on campus is subject to a mandatory expulsion. I just mentioned this because it is a subject that comes up in my work in student discipline and causes a lot of distress amongst staff in terms of how their hands are tied by the education code. But that unfortunately is where we are in terms of the law. There's also discretionary expulsion. And that's simply any other act, not all already mentioned, and also requires the supporting findings. Now, what are those supporting findings? To expel for a mandatory unless an appropriate or discretionary offense, there's two questions that must be answered, and it's an either or. One is that other means of correction are not feasible or have not brought or have failed to bring about appropriate conduct. And this is where I refer you back to that suspension statute that lists, it's the only statute that lists other means of correction. And then secondly, whether due to the nature of the act, the presence of the pupil causes a continuing risk of safety to that pupil or others, to the school community. Those acts which are so extreme relatively that that expulsion is the logical conclusion for school staff. There's also limitations on the jurisdiction for student discipline. Obviously, there's jurisdiction if it happens on a school campus. There's jurisdiction if it happens at a school function. There's jurisdiction if it happens at a school function of another school, a sporting event, for example, a visiting where one of our students is part of the visiting team. There's lunch on and off campus. There's also during, while going to, or coming from school. So going to school or back from school. A disciplinary incident that happens during that time period, there is jurisdiction to discipline. Those raise lots of questions about what it means to be coming from school or going to school, but that is jurisdiction. I'm also going to mention, I'll mention it later, that there's another jurisdiction which is a nexus to the school environment, which is very important when we talk about cyberbullying and what happens when students are interacting online. Now, in terms of timing for an expulsion or an expulsion recommendation, the education code requires that the timing, the recommendation occurs after determination of the act, after school staff has determined that a student has committed one of those acts. Now, the statute doesn't provide a specific timeline. It doesn't say 1 day after or 2 days after or a week after. But I think practically the information has to be acted on expeditiously. And when we get longer gaps, and sometimes these things happen, that raises those equity issues, those due process issues for our students. The educational code also doesn't provide a statute of limitations for bringing expulsion cases. Meaning that, for example, and this has occurred in school districts and neighboring school districts, that a sexual assault has just been discovered. Somebody discloses to school administration of a sexual assault that had occurred on campus maybe a year ago, maybe 2 years ago, maybe 3 years ago. Now, there is no statute of limitations, as I say, but those things too raise due process issues, important due process concerns that have to be worked through with administration. I'm going to stop here for a second and see if anyone has any questions. Yes.
I have a couple questions. If you're using the word equity in a couple of ways, like one process and another that people just want to hear a little bit more about how you're defining equity. The way I this work is to do this around race and history and the proportional impacts that these actually challenge people are. So could you define a little bit more about how you're using that process?
Thanks for bringing that up. That's probably just me not being very careful in my use of terminology. You're right. I use equity in the same sense that you're using equity. I'm using due process in the sense of what is fair within any specific disciplinary process to a student. What rights is that student afforded within the disciplinary process? And also, when we think about due process outside of the student context, we think about the prejudice to a student, for example, of bringing a very old allegation forward in terms of discipline. Where does that student have the ability to appropriately defend him or herself? There's also the due process in terms of waiting too long of a period between determining that something has occurred and then making the decision to discipline. All right. There's a specific evidentiary standard in the education code that must be met in order to discipline a student and expel a student. That's called substantial evidence. So what that means in the education code is it must be some direct evidence on which a reasonable person could rely and to support each required finding, whether that is each part of the alleged offense or whether that is the secondary findings. Each finding has to be supported by substantial evidence. Now, in terms of school discipline, we don't have trials, and neither does the education code really presume or want districts to have trials. They want to have hearings. They want to have hearings that are interactive, that protect the rights of the student, but also allow allow the realities of what it is to be a school administrator and to investigate a disciplinary issue. And in that, the education code allows hearsay evidence. Hearsay evidence is defined as evidence that's not based on the person's personal knowledge, but based on what someone had told them for the truth of the matter asserted. But one thing that cannot happen, very specifically in the education code, is hearsay evidence can't be the sole basis for a decision. And how does this come up in school discipline cases? This comes up in school discipline cases when students all right, okay, sorry about that. When a school site administration attempts to base disciplinary charges simply on reports of conduct without having any of that direct evidence of the conduct happening. If someone brings an item they are not supposed to have to school, but and all that you know is hearsay that person had that item, that is not enough under the education code to discipline a student. You have to have that direct evidence. Sometimes that direct evidence, though, can fall within what we call in law the hearsay exception. And those hearsay exceptions are the admission of, and I hate to use this term, but this is the definition in the law, a party opponent, which in our case is the student facing discipline. Often then that becomes the student's statement to school site administration during the investigative process. If the student admits to committing some sort of offense, that can be direct evidence, the sole direct evidence to support disciplinary findings. There's also things like statement against interest, official records, and confidential witness statements, which I'll get back to a little later. Or not, please go ahead.
So are students allowed to be interviewed or, given the admissions of guilt without a parent present? Because I know that has been an issue in the past in various schools.
The most direct answer to that question is yes. A parent does not have to be present in terms of school site administration interviewing a student. It is different when law enforcement is involved, whether that be outside law enforcement or a school resource officer. Law enforcement under the education code is held to a higher standard in terms of interviews of students than school site administration. Again, the education code is built with the exception of law enforcement, even district controlled law enforcement. There are a few school districts that still have their own police departments, but those that do. It is built to give flexibility to school site administration, looking at the realities of what it is to investigate conduct on a campus.
Is that part of local parentis?
Say that again?
Is that does that fall under local parentis, given, the school side's the ability to be the parent in charge? Is that how?
Yes, it does fall under in loco parentis, and you see in loco parentis come into play with searches. I'm not going to cover searches in this presentation, but the idea of school administration being able to search, for example, a student's backpack upon reasonable suspicion, rather than a higher probable cause standard, which would apply to police, is because schools stand in what's called in loco parentis. So they may act just like a parent may act during school hours in having control over the student body.
So an example of these students that may be admitted to guilt, like within the school, but didn't have a parent present. Given the higher standard for law enforcement, if those charges or whatever were to be used by law enforcement, they wouldn't be able to use those admissions because they didn't have a parent present, or could that be used against them outside of the school jurisdiction?
It's an excellent question. I believe it could be used by law enforcement or prosecutorial authority if a student made an admission to school staff, but that would be true of any admission made to any person following an incident. The prohibitions under the Fourth Amendment, under Miranda, apply only to law enforcement because of the status that law enforcement presumably have in our civic structure, and the power that law enforcement has inherently to detain people, to arrest people, to investigate. Because of the higher authority that law enforcement have, there are higher standards to law enforcement. But to answer your question directly, I don't see sitting here today a prohibition of law enforcement to use a student statement. Now, there is an opposite issue that comes up that I'll mention. I don't know if I have a slide about this, but the opposite issue that comes up is when law enforcement is involved, districts have to do their own direct investigations of disciplinary incidents, which means that it is incumbent upon school site administration, if they believe that law enforcement may become involved or immediately involved, to do an independent investigation in order to preserve the ability to discipline the student if need be. Because once law enforcement becomes involved, it's no longer the district administration that has the information, it's now law enforcement. And then you have that hearsay exception that starts to come into play. Hopefully that makes sense.
It makes sense, but it just seems like I would want students and their families to know that there's that potential for what they say could be used against them later on. Just from a your rights type of perspective.
And I understand that. I think there are obviously this district, like many of your neighboring districts, like many of our clients, are very concerned about the criminalization of behavior on school sites. That there are multiple levels to that. One of which is whether school sites notify law enforcement, whether school sites are under legal obligations to notify law enforcement, because unfortunately there are legal obligations under certain circumstances to notify law enforcement in the education code. When law enforcement, let me provide an example, which is probably the most troublesome example, and I hate to bring it up, but I think it's illustrative. A student brings a gun to campus. Clearly, law enforcement is going to be involved. It's a minor in possession of a firearm. But the district's interest is also going to be in appropriately being able to handle that situation in order to, under the education code, under possession of a firearm, it's a mandatory expellable offense, and it's a mandatory expulsion. The school district, in the same way of needing to protect the safety of students, may also need to move forward with expulsion of that same student. And if in order to do so, the district needs to interview the student, that's when this unfortunate that you bring up, this unfortunate tension comes along, right? Of a district being able to protect the safety of the school environment versus a legitimate concern about the criminalization of student behavior. I don't know if I have a good answer for that, how you bridge that gap, where you draw the line, other than to say that it is a real concern. And it's a concern that I know that I speak about with clients, including administration for this district.
That, it's not just our responsibility to keep our schools and our students safe, but I think also part of our oath to defend the Constitution, and that's kind of what I'm trying to understand here.
Sure.
Director Fong, do you have a question?
Thank you, David. And this might be getting into the weeds, and you can say if it is, and we can maybe cover this later, but it's actually a two-parter, and it's
Sure.
kind of following on Director Vice President Medina's. You talked, David, about when must schools notify law enforcement? And then once schools notify law enforcement and an officer is there to speak to the student, must we, or when must we bring the parent in? And I think you'll probably be talking about this, but.
I am not prepared today to talk about the specifics of when schools must identify law enforcement. There are a few examples. Guns is one of those examples. Serious bodily injury, I believe, is another example of when law enforcement must be contacted. To your second question, when the advice that that is commonly given to school sites when law enforcement may be involved is to speak with the students first. Because of the inability to potentially go forward with discipline if school sites do not speak to the student first. When law enforcement shows up, and forgive me if I'm not answering your question, please stop me if I'm not. When law enforcement shows up at that point, and this was a change in the law about a year or two ago, maybe longer. Law enforcement is now required, unless it's an emergency situation, to contact the parent, to have the parent be present before any custodial interview of a juvenile occurs. And this is both within the school environment and outside the school environment. That can take some time, obviously, and it also, again, as I said, once the law enforcement interview, let's say a student is taken into custody, then a district loses that ability to directly speak with the student and collect the evidence it may need for its processes.
So let me just make. We find out that a child has a knife or possession for sale or a weapon. We immediately call law enforcement. We're continuing to try to question the student, not cooperating. Let's just say, officer comes in. When does school have to call? Not advised to call, have to call parents.
That's a good question. Sitting here today, I am not sure, and I would have to look back at the education code in terms of those few sections about notification of law enforcement, whether they have a parental notification requirement as well. They may. In terms of law enforcement, again, law enforcement, once if law enforcement is taking a child into custody, and there's a whole legal standard under the Miranda line of cases as to when a person is in custody. So it may not be arrested, it may just be when they're sitting in a room and they reasonably feel like they can't leave. That is defined as custody in criminal law. At that point, if law enforcement wanted to question a student under current law, unless it's an emergency situation, and if the emergency situation could be, we don't know where this gun is, we need to find out. But absent that, in an emergency situation, law enforcement would need to contact the parent before any questioning happens.
There we go. Along the same lines, if the student is, I don't know, is there a contradiction, I guess, between the identification of the student, if the student is 18, if the student is an adult, from what the school does and what if law enforcement's on the scene?
Yeah. I think at this point, I want to stop because I don't want to risk, when I'm trying to remember off the top of my head these intricacies, saying something that is that's not exactly correct. I think that this board, if the board wants, could have an entire different training on the interaction between law enforcement and other local and county organizations in terms of student discipline, because there's law enforcement, there's when students are foster children, there's very specific requirements for notification there. So there's a lot of intricacies in that, which I didn't come here today to prepare to answer in depth. So I think maybe it would be best, before I say something I'm going to regret later tonight, to just put a pin on that and be prepared maybe in a future meeting to talk to you about that.
So you might be able to answer this one. in lines of what Director Fong mentioned, someone bringing a knife on campus, that doesn't necessarily fall under the expulsion rule. It needs to be, that knife needs to be brandished, right? Is that correct?
Well, whether it falls in the expulsion rule or not, it depends whether it's, I think your question is it a mandatory expulsion only when brandished?
Okay,
Is it an expellable offense? Theoretically, yes, but
Yes.
that would require secondary findings.
okay, so hypothetical, kid brings a gun, a rifle after hunting with their parents. It's in their car, it's locked. And this actually has happened.
Mhm.
So, yes. So, where does that fall under? You know, there is a gun on campus, right? And is that a shawl or, I mean, law enforcement? Especially here in Sonoma County, right? A lot of families go camping and hunting. So what happens then?
The straightforward answer and the unfortunate answer is that under the education code, that's a shall. It's constructive possession if it's in the student's backpack, even if the student isn't near the backpack, just the same as it's in their car, in their trunk. I think my example of drug sales, and maybe it's not a great example, but I think it's a more and more a reality of schools, especially with marijuana use. Those are the places where the education code has not caught up to those realities. A student who hunts, who puts their gun in the back of their car and leaves it locked, and somehow it comes to light that they have a gun in their car. Yes, it's unfortunate that it falls on the line in the education code of a mandatory expellable offense. That's really all I can say about that without really knowing, going into some intricacies of board discretion. Although if you read the education code straightforward, there is no discretion for anything other than to expel a student for one of those 5 offenses.
Director Zalekos?
No, maybe. Just keeping it. Thank you.
One of the things that I was interested in, I didn't see a slide on this, and so maybe it's just added to the parking lot of things that we're interested in hearing about later, which is, what are those legal obligations that we are under to notify law enforcement? Because that feels like a rich area for policy for this board, which is to say only for those things, that we are legally required to notify a law enforcement agency, shall we? Because I think in particular, what we have seen and heard from our law enforcement agency is a real inability to distinguish the negative consequences for undocumented students versus those students who undocumented as well as legal permanent resident students, immigrant students, essentially, right? Versus citizen students, and recognizing that there are significantly disproportional impacts that can happen for immigrant students as a result of coming into contact with law enforcement. Not even, right, after ultimately being charged and convicted with a crime, just touching the criminal justice system causes a risk of harm to that student as well as to their entire family. And so I'm really curious about the space that we can create as an institution to say we have a capacity to know our students in a little bit deeper of a way than maybe our law enforcement agencies do, because we serve them every day. We know who they are, we know their families. And so limiting that reach of a law enforcement agency inside of our institution seems to kind of take away our discretion in a number of different ways, but in particular also kind of create this whole area of harm that our institution doesn't cause as a result of discipline, right? So I just wanted to hear a little bit more about whether or not you are prepared tonight or at another time to talk about, you know, what those legal obligations of our district are to notify law enforcement.
Right, you know, and as I was telling Trustee Sheffield, I am not, I don't, well, first of all, I wasn't prepared to discuss this in depth tonight, other than just to mention it. And so I think it would need to be another training. Now, there is a warren of statutes. The education code, there's many judges and those of us who practice in education law who call it Byzantine. If in my office, there's these onion paged education codes. There's 2 volumes of them that are each about 5 inches thick. There's a lot in there. And so there are a lot of different statutes that address and touch upon law enforcement contact, some of which are contradictory. And so I want to make sure that in order to do this conversation justice, that maybe I come back really with a very fine-tuned presentation to law enforcement involvement in schools. All right. With that, I'll go back to my very general presentation. Confidential witness statements. These are witness statements. So often in disciplinary proceedings, you'll have witness statements where the witness signs. It's part of the packet from administration. Sometimes you will have the need, or school sites have the need, to have confidential witness statements where the identity of the witness making the statement is protected. This most often comes up in sexual assault cases or sexual misconduct cases with the victim. There is a determination that must be made by the hearing officer or the hearing panel as to when a confidential statement can come in. And when it does come in, it is testimony, meaning that it is not hearsay, meaning that for example, sexual assault victim can write his or her story in a statement and have that presented because of a fear of psychological or physical harm. And that is taken as if that person has come in and told the hearing panel his or her story directly. There's other very special rules for sexual assault victims. There's notice requirements for testimony for sexual assault victims. There's rights to adult support persons in hearings. If there is an open expulsion hearing, which I have to say is very rare, but if there is an open expulsion hearing, a sexual assault victim has a right to close that portion of the hearing in which he or she testifies. They can also have the ability to testify in a separate room away from the accused. There's also a bar, much like civil law and criminal law, much like the evidence code, a bar on testimony regarding past sexual conduct of the complainant, unless there's a finding of extraordinary circumstances. I'm also going to mention that when it comes to discipline for sexual assault and harassment, we also bring in Title IX. Now, the prior federal administration changed the Title IX rules in, I believe, 2020, making the requirements for discipline much more stringent. The requirements for notice, for investigation, for hearing, much more stringent. It's expected that in the spring of this year, the current administration and the Department of Education are going to issue new guidelines. These guidelines are expected to go back to the way that Title IX was treated previously in terms of investigation. There still has to be a separate investigation, but that is handled more like a uniform complaint rather than the current Title IX procedures. Until that time, though, and just so you know, there is a very real legal tension between the timelines in the education code, which are very short, and Title IX, which requires all Title IX procedures to finish before discipline. This means in the real world that Title IX investigations can take months. And that means that during those months, the accused can't move forward to, or the district can't move forward to disciplining the accused, which implicates timelines that I'm going to discuss in a second. There's also special considerations in terms of bullying and electronic acts. And a careful consideration that has to be made between free speech and what is not free speech. As we know, the famous saying, free speech does not stop at the schoolhouse door, but free speech is less within school environments. The most direct and simple way to talk about this difference is whether the speech is directed at a specific person or specific persons, whether it occurred during the school environment, whether it was directed at the school environment, or whether it caused substantial disruption to the school environment or harm to the person. Now, going back to expulsion timelines, we talked about determination of the principal or superintendent. Once that determination is made, there can be an extension of suspension pending expulsion. It's not required to extend a suspension pending expulsion, but it is allowed. That has to be preceded by a meeting with the student and the student's parent or guardians. And then the time to hold an administrative hearing panel or board hearing is 30 school days after the determination. There's a couple rights that a student has to extending that. One is that a district must grant 130 calendar day, and it is a constant source of confusion, the education ghost's use of calendar day and school day. But it's a 30 calendar day extension upon a parent or guardian's request. That's automatic. The board may grant additional extensions at the request of a parent. And then the district itself may extend by 5 school days. We come back to school days for good cause. There's notice requirements in terms of a hearing. A student must be notified of an administrative hearing panel hearing, or in school districts that hold expulsion hearings before a board hearing 10 calendar days prior to the hearing. And within this, there has to be a statement of rights afforded to the student. That it includes the rights to present evidence, the right to question evidence, the right to legal counsel, or a representative. The student may also ask the board to issue subpoenas. This is relatively rare, but it does happen. It happens more often when a student is represented by legal counsel. When a student asks for a board to issue subpoenas, that request goes to the board, and it is wholly discretionary as to whether a board issues a subpoena or doesn't issue a subpoena. Strangely, the education code doesn't really raise how a board can enforce a subpoena, or what a subpoena that is issued from a school board looks like, but it is part of the education code. After the hearing, there's 30 school days to have a hearing, and then 40 school days from the recommendation to make a decision on the recommendation for expulsion. Or if a board holds a hearing directly, the board has 10 school days effectively after the hearing to make their decision. During the summer, these timelines can get extended. 1 business days count as school days during the summer, but when the board takes an extended recess, which is actually defined in the education code as longer than 2 weeks, then all these timelines are told. The board has a few decisions to make, as you know, in terms of an expulsion. One is not to expel. With few exceptions, when the board decides not to expel, a student has an immediate right to go back to his or her prior placement. There can not be conditions placed on a decision not to expel a student. There's the decision to expel. It's either until no later than the next semester, which means that a board can set an earlier date, or for 48915C, and I list here what 48915C means, a board shall expel for a full calendar year. That is what the education code says. Shall. Lastly, a board can suspend enforcement of an expulsion. The question has arisen, and this is one of policy. Question has arisen as to where the suspended expulsion decision should originate from. It can originate from a panel, and sometimes it does. There is nothing in the education code that requires a panel to recommend suspended expulsion. It is ultimately the board's decision, and a district could have a policy that those decisions are solely the board's prerogative, meaning that an administrative hearing panel can only vote to expel or not to expel, and then leave it to the board to decide whether to suspend enforcement. When the board expels, there has to be terms mandated by the education code, which includes referral to community school program and a rehabilitation plan. A rehabilitation plan include things like improved academic performance, tutoring, counseling, a special education assessment, although the board can't mandate an assessment, but can suggest it. Job training or employment. This is in the education code, and I have to say that I've never seen this as a board recommendation for a rehabilitation plan, but I thought I'd list it in there because it was in the education code. Also, community service or other rehabilitative programs. When it's a 48915C expulsion, which was one of those 5 that were listed previously, there are mandates, shalls, that the board must do. One is a recommendation, a placement at a school, usually a community school, that is appropriately prepared to accommodate pupils who exhibit discipline, that cannot be located at a comprehensive campus, and is also not housed at the school site already attended by the pupil. Suspended expulsions provide a little bit more leeway for boards. The rehabilitation plan could be for 1 year, even if the expulsion would only be for the remainder of the semester and up to the end of the next. The terms can include moving to a new program, counseling. Rehabilitation plan can involve parents, although it can't require that as a condition of being rehabilitated that the parents participate. The student then becomes what is called being on probationary status for 1 year, or for whatever the term of the rehabilitation plan is. That probationary status means that any further violation of 48900 may lead to enforcement of the expulsion. After 1 year, the board must readmit the student, and it may expunge the expulsion. Yes.
Are suspended expulsions available to address mandatory expulsion grounds?
That is really an excellent question. As an attorney, in looking at the education code and looking at the sections and the interplay between them, I do not believe that they may. This is not a settled question of law. And unfortunately, in student discipline, there are very few cases that move up to civil court or the Court of Appeals, where one might look for guidance. So there's very little guidance. The reason why I doubt in terms of my view of the education code, my reading of the education code, that suspended expulsion is available is because the education code requires the board to refer the student to a community school. It has very, very specific requirements for what a board has to do when a student is expelled for one of those five offenses. And to me, that creates a tension, because if the board is suspending enforcement of the expulsion, then by definition, the student is not going to a school meant to or designed to address students who exhibit disciplinary needs. Go ahead.
Sorry, I'm laughing because I'm like, why are public schools not equipped to deal with students with discipline problems? Right? Like, isn't that a function of
Yeah.
educating young people?
And I think it is, when the last time I did this presentation or a version of this presentation to school staff, I made the joke, but it's sort of true that, the disciplinary sections of the education code, were primarily written in the 60s and 70s. And I think really is sort of stuck, other than electronic acts and cyberbullying, are really sort of stuck in this 1980s version of high school. And sort of ignores the fact that schools are better prepared to address the social emotional needs of students. That there are certain ways that students engage in misconduct that are just simply not anticipated by the education code. Actually, maybe at best, the education code is in an early 90s view, so pre-internet age. It doesn't anticipate students having cell phones, where a message on a cell phone could cause, as I said previously, a severe disruption to the school environment that requires some sort of administrative reaction because maybe the community is now upset. So this is just an unfortunate tension in the education code and how it's written. So in terms of consideration of expulsions, deliberation must be in closed session. The education code says that if any other person is admitted to the deliberation, then the parent or guardian must be allowed to attend. I put a note in here. It's not stated in the education code, but a board, just like any institution or any person, is entitled to legal counsel. That does not change. That does not open up the board's closed session. Then the final action, what's called quote unquote the final action to expel a pupil, must be taken only in open session. I'm going to note here that the education code does not address what happens with stipulated agreements for expulsion, whether a vote needs to be taken in open session or not.
So, yeah, under any other person admitted to closed session or closed deliberation, is there a list of the folks that are allowable in closed session during deliberation?
The list in terms of deliberation, and then I think if we want to put a finer point on it, what is deliberation? Is the board and the board's legal counsel, if the board wishes to have legal counsel there. Now, when I read the word deliberation and sort of its normal use of the word in the law, that means when the board is discussing what action it is going to take.
So anyone else except legal counsel, if we have anyone else except for legal counsel, then we must allow the parent and the student to be there.
Yes.
This includes staff.
This includes staff, which is why there is a practice I know in this district in the past and in other districts to exclude staff once deliberation begins, and that deliberation being the discussion amongst the trustees as to what action is going to be taken. Now, there also has to be a presentation of the, if you have an administrative hearing panel, the administrative hearing panel's recommendation to the board. That presentation is not deliberation in that plain meaning of the word. So then that becomes, if that presentation happens in closed session, because it must happen in closed session, then when the deliberation starts, that is when it must only be the board.
Director Medina.
Yeah, so this last part on final action, taken in open session, I just want to clarify. What does that mean? Is that the actual vote taken in open session?
That is the most straightforward reading of what final action means. And actually, I think maybe Anita is going to have, as a Brown Act expert, what a better statement as to what final action means in terms of board action.
That would be the board vote should happen in open session.
Okay, and again, I think we reviewed this, that in our board policy, it says a vote to expel a student shall be taken in open session. I just want to figure out.
Now that obviously doesn't preclude a straw vote to be taken in closed session. It just has to be public, the vote that is entered into the minutes of the board.
Oh, that will be a roll call in open session?
Yes.
Okay.
Oh, right. Okay. There are appeals. Maybe I should do a time check because I know I am. Maybe there is no time check to be had. Okay.
And I think the content is really important.
Okay.
For the board.
Great. I will soldier on that. All right. Now there is a right to appeal as part of a student's due process rights. This is part of the notification that's provided to any student who's subject to expulsion. That right to appeal is to the County Board of Education. There's a 30-day deadline to appeal. That is to send a notice of appeal to the county board. The county board then handles the procedure going forward. So county board will notify the district and the student as to their own procedures, and each county board has sometimes unique procedures within the context of the education code. County board action is limited to a few questions: whether the district's governing board acted without or in excess of its jurisdiction. That usually means whether in layman's terms, whether the board had a right to discipline the student for that conduct, or whether the district had a right to discipline the student for that conduct. Whether there was a fair hearing, whether there was a prejudicial abuse of discretion, and that includes whether the district has not met its procedural requirements, whether the decision was not supported by the findings prescribed in 48915. In that case, it results in a remand to the district board to adopt findings, or whether the findings are not supported by the evidence. And then the last one is whether there's material evidence which, in the exercise of reasonable diligence, had not been produced or was excluded improperly from the hearing. In that case, the county board does have the power to hear the case de novo, meaning that they can hear the expulsion case all over again in front of them, or they could remand back for another hearing to meet those requirements.
We have another question, David.
course.
Director Lenectus.
Thanks. I wanted to go back a slide where we were
Try to
talking
go back a
about
slide. All right.
board
Oh,
being
no, that-
entitled to legal counsel during deliberation. And this is kind of like just generally this question around entitlement to legal counsel and or any concerns that you would have about our school system or our board also providing recommendations and or referrals to the student and their parents for legal counsel as well. In the hearing and or appeals process.
Sure. So please go ahead.
There we go. On slide 28, you had noted that education code does not address stipulated agreements too, and maybe you could discuss a little bit of that as well.
Sure. I accidentally closed all my slides. Let me just get back to that for a second. Oh, I did it again. Second. Well, let me answer the questions and I'll do the tech. In terms of attorney referrals, I think that any institution that starts providing lists of attorneys, either specific attorneys, well, let's say specific attorneys, runs the risk of an allegation that the list is incomplete, that it misled parents or guardians, or that the attorneys on the list were not appropriate or somehow in collusion with the district because they're on the list.
Yeah, I guess I was thinking about even just a statement like you have the right to an attorney and here's how you could find an attorney. And here are some attorneys that provide no cost services if you're eligible. And here's a way to find an attorney who's a private attorney, like through the county bar referral system. So just, do you have any concerns about, I'm not like speaking about like, you should call Fred because he's awesome. He always finds for us, right? Like,
so the statement of you can have an attorney is always part of the notification. That's always part of the rights that a student has in the notification of hearing. In terms of a list, I think that a district that wanted to provide a list might turn to the local court system and a local court system's list of free or low cost attorneys. Presumably the court system is maintaining that list because these are organizations, and we know what those organizations are. Usually legal aid or there's a farm workers assistance legal organizations. Or clinics that are tied to law schools, things like that. So that I think is probably the best place to turn, because theoretically that has already been vetted through an existing court system, rather than a district creating its own list, which would create issues, potential liabilities. All right, now I need to try to do this tech. Give me 1 second, I apologize. All right, I think we're back. Okay, so I was turning to readmission after expulsion. That is a board decision. Readmission is required after successful completion of rehabilitation, unless the continued presence of the pupil is a danger to campus safety or the safety of pupils or staff. The education code, though, is strangely silent on what happens when readmission is denied. And readmission is usually denied when a student has not completed the terms of their rehabilitation plan, or has, whether or not keeping their grades up, whether or not attending school, whether engaging in other disciplinary conduct while expelled. Go ahead.
So If we have students that are expelled and they decide to go, I don't know, out of the county or out of the country, right? Or out of state. And a year later or a year and a half later, they decide to come back. Must we accept them? Since they haven't technically completed their rehabilitation program because of attendance issues and whatnot, right? So is that a must? Is it a must that we have to do, even though they haven't done the rehabilitation program, or is it at our discretion?
So it is if a student has completed the rehabilitation program, it's a must. If a student has not completed the rehabilitation program, the board has discretion to readmit the student. The last point on this slide is that when readmission is denied, there's no procedure, there's no standards for what happens. My advice that I give to clients as the best practice is to set a new date of potential compliance, which could be simply the end of the next semester, or the end of the current semester or the end of the next semester, to provide appropriate goalposts for the student to come back to readmit, to apply for readmission again. It's not a one and done. It's not if a student is denied readmission, they can never come back to the district. But again, the education code is just completely silent on what a district does once it denies readmission. A school district can admit a student expelled from other districts other than for one of the 5 big offenses, 48915C, where a student cannot attend any other district. But students from other districts who are expelled can ask for admission. And I believe my slide is not accurate, so I will just tell it off the top of my head, which is that a student from another district, a board can deny admission. They can grant admission unless the board believes that the presence of the student might cause a danger. And the board can also grant a qualified admission, effectively a probationary admission of a student from another district. I'm going to talk just very briefly about special education, disability, and student discipline. Students who are disabled have additional protections under federal and state law, under the Individuals with Disabilities Education Act, under Section 504 of the Rehabilitation Act, under the Americans with Disabilities Act. There's also far more oversight of any school district that is disciplining a disabled student. That comes from the Office of Administrative Hearings, which is a state agency that contracts with California Department of Education to hear special education matters. It can come directly from the California Department of Education through a compliance complaint. It can come from the Office of Civil Rights of the U.S. Department of Education, and oversight can also come from state and federal courts. There are 3 categories of removal when thinking about removal of disabled students. Category 1 is anything 10 days, removal for 10 days or less in total. The general education discipline rules apply, but there also has to be a determination on a case-by-case basis if the removal is inherently unfair. And if it is, there should, or should there be a consultation with special education administrator who is familiar with the student's disability and/or the student's IEP team. Go ahead.
So these are cumulative, right? Days in one school year.
There are cumulative days in one school year, and it resets at the beginning of each new school year. When you're talking about cumulative days, the law is a little bit more nuanced. It is, and this is actually in this next slide, is the proximity of the removals to one another but more importantly, whether the behavior was related or not. A student who is removed for the same or similar behavior again and again and again, once they get over 10 days, procedural safeguards are triggered. A student who is disciplined for different behaviors at different times that are unrelated, the protections need not necessarily apply. Now, best practice is whenever a student who is disabled gets over 10 days of suspension for whatever reason within a school year, hold, and we'll talk about it in a second, a manifestation determination, and not to try to it invariably leads to messy disagreements and legal fights as to whether behavior is related or not. So that was category 2, which is it's over 10 days, but maybe they're not related. And as I said, category 2 is not necessarily the best practice to take. And then there's category 3, which is over 10 days. An expulsion recommendation is automatically a change in placement. It doesn't matter if it's after 5 days of suspension, if it's when the student has been suspended for 3 days. Once the expulsion recommendation occurs, it becomes a change in placement, triggering procedural safeguards. And as Director Flores, you asked, it resets each school year. Now, students also have a specific right, disabled students also have a specific right to services after the 10th day. Of course, this does not mean that you do not provide your general education students with education and services pending an expulsion or after extended suspension. But this is only to say that that law requires very specifically for services to be given to disabled students. So it's educational services that allow students to continue to participate in general education curriculum and to continue to progress towards his or her goals and objectives in his IEP. It also, or his or her IEP, this also requires an IEP member or team consultation, depending on the length of the removal, to decide how are we going to support the student in the removal, let's say it's pending expulsion.
Sorry, I have a quick question.
Of course.
And it's actually probably for Superintendent Chanel or staff, but do we keep data on expulsions and suspensions? And what I'm thinking about is how do we as a board understand the inequities that our students may be experiencing if they're in special education, or if maybe we're actually doing better than our general student population in this area. So just understanding what's going on in our district.
So we do keep records. We're required to do that. And at a future special board meeting, we'd like to discuss that data with the board.
Thank you.
The last thing that needs to happen for a student who is removed for more than 10 days is to receive as appropriate what's called a functional behavioral assessment. It's a type of special education assessment to address the student's behavior, the function of that behavior, and to come up with a plan to address the function of the behavior, and to provide behavioral intervention services and modifications to address that behavior so it doesn't occur again. Now, a manifestation determination meeting has to be held upon a removal. It has to be held within 10 school days of the incident, or I'm sorry, 10 school days of the removal. That's a typo. It includes all relevant members of a student's IEP team, including the parents. And the team has to review all the relevant information, including the IEP, observations, parent input, and determine one of two questions. One, whether the student's conduct in that incident, and actually more specifically in the incident leading to let's say a recommendation for expulsion, whether the conduct was caused by or had a direct and substantial relationship to the student's disability. And second, whether the student's conduct in the incident was a direct result of the failure to implement a student's IEP, then existing IEP? If yes, please go ahead.
IEP and 504, right?
Yes, I'm gonna get to that and I'll get to that in 1 second, but you're absolutely correct. Oh, 504. If yes, if the answer to one of those questions or both of those questions is yes, then the team must conduct a functional behavioral assessment or review a existing behavioral intervention plan. And the student has a right to return to his or her prior placement unless the parent consents to a change in placement. Just like a board decision not to expel a student, you can't mandate the student go to a different placement. In a manifestation determination, the IEP team cannot mandate, with few exceptions that I'm not actually covering here, but with few exceptions, that the student go to a different placement. If no, then the pupil is treated for disciplinary purposes as a general education student. Now, Trustee Flores, in terms of 504 protections, there are similar protections under 504, but 504 doesn't contain all the protections of the IDEA, nor does it mandate the very specific findings that the IDEA requires in terms of a manifestation determination. Best practice and the advice we give all our clients is to use the exact same standards that one uses under the IDEA for a 504 manifestation determination. So that's the questions were the relationship with the disability or a failure to implement, the conduct was directly caused by a failure to implement here the 504 plan. And that is the end of my presentation, Director Flores.
Generally speaking, who holds these hearings, the MD hearings? Is it site-based? Is it district-based?
The manifestation determination.
Right.
The manifestation determination, it's not a hearing, it's a meeting of the IEP team or the 504 team. And they answer those questions. And it's up to the individuals who serve the student, who assess the student, who are knowledgeable about the student's disability to answer those questions. Under the IDEA, there is a right to an expedited due process hearing in front of OAH to challenge a manifestation determination finding. There are very robust procedural safeguards afforded to students who are eligible under the IDEA. Under Section 504, there is also a right to request a hearing. The standards are much looser than in the IDEA, and if and when a district ever has a Section 504 hearing, usually what that entails is the district hiring a independent hearing officer to conduct a hearing, much like the Office of Administrative Hearings would conduct the hearing, but a independent officer to conduct a hearing and to issue a decision.
Question over here. I wanted to go, now that your slide is back up and running, back to slide 28. I did have a question about stipulated agreements.
Now you're making me figure out how to go back. All right, hold on a second. Sorry. Oh, there we go. Yes.
Okay, so you had noted at the bottom that education code does not address stipulated agreements. Does this mean that there are no parameters? Is it a good idea for a board maybe to set up policy parameters in situations?
The specific, well, there is no education code provision that mentions agreements. The statement in this is actually simply in regards to Brown Act requirements as to how a vote on a stipulated agreement might occur, whether that can occur just like any other agreement regarding a student as is required in closed session and then reported out, or whether that vote has to track expulsion votes and that the vote on final action has to be taken in open session. You can look at it in two ways. You could look at it as simply an agreement, and therefore as an agreement regarding a student, it can fully be done in closed
But
session.
it's
You could
solely a
also-
board decision.
You could also look at it as an agreement, but an agreement for, let's say, an expulsion or a stipulated expulsion, in which case you could view this, you could view the education code as requiring the final action be taken in open session.
Okay.
There's no clear answer. There's no clear guidelines. Of course,
Yeah.
as I said, there are no cases on the subject. And so it's the board could have its own policy on how it wants to handle the votes regarding stipulated agreements. Now, whether and when to enter into stipulated agreements or how
That's the
to
second part
offer
of my question.
stipulated agreements, I think there's nothing in the education code that requires a district to even offer a stipulated agreement. But again, there's nothing that prohibits it. And there are times when a parent may want to have a stipulated agreement. I was seeing in internal chatter, and not to mention any clients or any specifics, but a parent who did not want to have a hearing, but also did not want to enter into an agreement. You have to have a hearing at that point. So the board may and can, and if the board wants, should set up standards on when a stipulated agreement be entered into. There's also discretion for the board to set up internal standards within the confines of the education code as to when disciplinary decisions are made.
Yeah.
For whom disciplinary decisions are made, whether that's age. We already know for 48900K, which is willful defiance, that at this point is barred for as grounds for suspension for anyone up to 8th grade. And in fact, there was legislation proposed. Now that means that it's very early and we have no idea what the traction is, but there's legislation proposed to get rid of 48900K altogether, that willful defiance. So that's a legislative limitation on the use of the education code disciplinary provisions, but there's nothing that prohibits a board from also having internal policies on
Okay.
how to do it.
Okay, thank you.
I have a question. I'm still trying to understand the relationship between a mandatory recommendation for an expulsion and a suspended expulsion. My understanding thus far is that the outcome for a mandatory recommendation can be changed through negotiations by a parent or by some sort of representation that a student might have prior to a hearing. Is that correct? What I want to understand is what options does a board have when it comes to a mandatory recommendation for an expulsion? Do we have to expel a student, and by expel, I mean remove out of our district, or can we have a suspended, is it our prerogative to move forward with a suspended expulsion,
Sure.
even if the child or the student doesn't have someone to negotiate on their behalf?
So when I hear your question, first of all, we're going to limit this to mandatory recommendations and mandatory expulsions, as opposed to mandatory recommendations but discretionary expulsions. And I pulled up this slide for you because 48915C has very, very special rules for what has to happen, shall happen to a student who is expelled for one of the offenses that fall under 48915C. And I'm just one attorney. I happen to be the attorney presenting in front of you, but I'm just one attorney. This to me this requirement implies that there is no discretion. Because if a board is suspending the enforcement of an expulsion, then the board can't be sending that pupil at the same time to a place that's appropriately prepared to accommodate pupils who exhibit disciplinary problems, where it's not provided at a comprehensive school site and is not at the school site where the student already is. Although that one's a little easier because you could just order the student to another school site. But those first two you can't do necessarily if you have a stipulated expulsion agreement, because by definition I misspoke. By definition, in a suspended expulsion, I apologize. By definition, a suspended expulsion, that student is going back to a comprehensive school site. That may not, although to the earlier point about what school districts are prepared to address, may not be, quote, appropriately prepared to accommodate pupils who exhibit discipline problems. But certainly that second issue of not at a comprehensive middle, junior, or senior high school, that's the one to me that, and the first one, which implies that the legislature believes that all students who commit one of those 5 offenses are going to be removed for a full calendar year under these requirements.
Does a continuation high school, for example, count as a comprehensive senior high school?
Well, and here's the other portion of it is the shall expel, right? So the shall expel would presume that the student is removed from the district environment. It is a very interesting question, and I am never married to my legal conclusions. I am more than happy to be proven wrong. Whether a comprehensive, whether a continuation school. I mean, I guess the question is, does that continuation school share a campus with a comprehensive school or a middle school or an elementary school? Hopefully not an elementary school. Does it meet this definition as is contemplated by the legislature as appropriately prepared to accommodate pupils who exhibit disciplinary problems? I mean, some of this questions would require some legislative analysis, which clearly I haven't necessarily done, but again, sort of that facial tension between being able to send a student to suspend the enforcement and send a student back to a regular comprehensive high school. That's the piece that makes me uncomfortable with the idea that a suspended expulsion is allowed under the education code. Go ahead.
Okay, I must clarify by saying I don't do a lot of student discipline. Actually, I don't do any. But in the scheme of what the obligations of a county office of education is, they only have one service that they are mandated to provide, which is court and community schools. And so when you look at what the legislature intended when they created this disciplinary scheme, and think about what court and community schools, which is the only mandate of county offices of ed, there is this expectation that there would be this expelled student, mandatorily expelled student, moved to a court and community day school. The other thing is with continuation high schools, that would be an option for high school students. It would be difficult to think that there would be a place for only high school kids to go to a continuation high school, but not have that option available to middle school students because you don't have continuation middle schools. So I think a greater analysis around the legislative intent can be done. But if you look at the way the system is set up, unfortunately, it is intended to exclude the kid from the district for a period of a year. And there is a separate place for the student, which would be the court and community schools run by the county office of ed or other placements.
And I think Namita makes a great point. I just want to make sure, and obviously, you know, but for any members of the community listening in, a court school only serves students in juvenile hall, so they wouldn't be, that's not what Namita meant. But she is right that as a county, that is the county's obligation to, in this case, because students who are incarcerated in juvenile hall are actually no longer pupils of the district, they are now pupils of the county court school. But in this case, focusing on the community school, yes, the legislature, as Namita said, mandates those schools precisely to do this, accommodate pupils who exhibit discipline problems. And so that would also lend the idea that's not a district run school. There are some districts that run their own community schools, right? And so this would allow that, but those districts who run their own community schools fully expel students to those community schools. There's not a suspended expulsion where there's a referral to a community school. When that happens, I usually have, the few times where I've heard that happen, my reaction is that's an inappropriate rehabilitation plan. Because if you're referring the student to a community school, then you're basically expelling them. The rehabilitation plan presumes that the student's going back to a comprehensive school.
Thank you. Are there any other questions from the board? Okay, I just want to take a pulse check before we move on to the Brown Act. Do we need just a minute to stretch, get water or anything, or do we want to continue? Okay, yeah.
So you can tell that we really are interested in this.
I know. And I'm not blaming you for being interested.
The suspended expulsion, based on what it is that your advice is tonight, is essentially only available for things that are not around kind of the mandatory expulsion, the grounds for mandatory expulsion. Is that?
Yes, and so if we think back to those five, I don't mean to interrupt you, but I just want to sort of ground us in those five, and those five being possession of a gun, brandishing of a knife, and brandishing of a knife means using a knife that meets the definition of a knife under the penal code, unfortunately, but there's a lot of this that borrows from the penal code. Having a knife that meets the definition of knife under a penal code and showing it in a way that causes another person to fear that you are going to use it. Sexual assault. Possession of an explosive device. And then the last one, which I think causes the most, is maybe often the source of this unfortunate tension, which is dealing drugs on campus. I am not in any way suggesting that dealing controlled substances on campus is acceptable, but there is that reality of marijuana in the state of California and how it's become more socially acceptable, how your 18-year-old students could be able to use marijuana outside of school, but not in school. How students with a medical marijuana recommendation are able to use marijuana outside of school or in school. Now, of course, they shouldn't be selling it to other students. But I think if you think about, or at least as I think about the relative harm of these five big ones, that one in that specific example brings me trouble. Now, if a board suspending the enforcement of an expulsion for bringing a gun onto campus or for a sexual assault, I mean, those are the sorts of offenses that boards generally, by and large, would never consider.
Right. No, I mean, there are fact patterns that could result in a student brandishing a knife because they have been bullied and, and have experienced a number of unremedied harms
Yeah.
committed, right, and not addressed by the school.
Mhm.
And then that student was, pushed to the bounds of, or was handed a knife, by somebody else in the heat. Like there's so many different fact patterns that I think we would like to find ways to find some discretion back and to, and I think in particular, the things to me that are really important about the suspended expulsion is this idea that it can be remedied, it can come off of your record. It's not going to tarnish you for the rest of your existence as a student. And, because we also know that these kinds of experiences create the school to prison pipeline that are particularly, risky for students of color, where the incarceration rates, the policing rates, the sentencing rates are disproportional to their, to their presence in our society. And so I think my intent here is to try to figure out what are the ways in which we can limit our students, possibility of being put on that path because of, our perceived lack of power to use our discretion in a way that recognizes the ways in which, our institution connects to many others. And if we can limit the ways in which our kids slide into those other institutions because we haven't found, the right way to exercise our discretion in these areas, I think that's where we're really and we have these cases that don't feel right. And the options for our kids, a community school is actually what we aspire to be. In bringing, the resources of community-based organizations onto our campuses, where we send our kids who are expelled don't quite fit that terminology and that aspiration that we have as an institution. So we're, I think we're really, I'm really interested in continuing to find solutions that allow for some limitation of that slide right down into something that we want, and I feel like is my responsibility to avoid.
And I completely appreciate that. And I think the best thing that I can say, and I've said this again and again, and I'll say it again, is that this is my interpretation of the education code. Now it's based on a lot of reading of the education code, a lot of thought about it, but it's an interpretation. And because of that, there's nothing in the education code that says a district shall not suspend the enforcement of X, Y, and Z. It just seems that there is as I said, that inherent tension in the education code in terms of the district's obligations, what a district shall do.
So I have the education code is a permissive code. So unless it is mandatorily prohibited, I have always believed that the board can adopt policies to bring its value, judgment, community voice into its policy. And I think it's a good thing to put it in policy so that it's applied uniformly across all school sites. And maybe there is training around that, but unless it's strictly prohibited by the code, there is this level of permissiveness that is allowed under the code.
Yeah, and I think that the last thing I'm going to say about this, and again with the risk of going into policy, which I don't want to do, is that one, there's a question of if a board suspended the expulsion of a student who committed one of these offenses, no one has the legal ability to challenge that. However, if my interpretation or my legal interpretation were to be adopted by a court and something happened, that could bring liability on the district. And then the last thing is sometimes, when we think of equity, the equity you're talking about is is work. It's constant work. And once you start slipping on that, that's when the disproportionality comes back. When a statute provides no wiggle room, there can be no inequitable outcomes because it applies equally to everyone who does it. Okay.
I know, because we have inherent bias inside of our systems. And that's the equality versus equity challenges that we face every day. So there's actually, I mean, I understand that perspective, but I think that's exactly what, when you do equity work, you recognize that equality has failed us. It has failed Black and brown children. And that's why we see what we see. And that's why equity is, what we are striving to achieve, because equality has failed in America for lots of good reasons for many generations. So I'm sorry, I didn't mean to interrupt you, but I was like, no.
It's okay. It's okay. Again, I was risking going into a policy argument, and I'm gonna stop myself from doing that. We are here to support the board and the decisions the board wants to make. And we are here to tell you when those decisions are mandated, when those decisions are permissible, and when there's a big gray area that the education code doesn't address. And in those cases, we have to talk about the risks to the district of taking action or not taking action. And that we could have an entire hour conversation just about the risks of just in case a court down the road said you had to expel this student and you didn't. You violated the law, and because you violated the law, you caused this harm. I don't want to speak what that harm is because we can all think about the terribles that could happen. But that is a consideration that has to be made, especially when you're thinking about some of these, not all of them, but some of the subject areas of these five disciplinary events.
Thank you for that. I think the other thing that I want to lift up here is that, we want to do this in a way that also respects and understands the day-to-day realities of our administrators, of our teachers, and our staff, and their feelings of safety. And when they are telling us how they feel about a student being in their school, that's real. And I think, weighing staff safety and those determinations that happen on a daily basis with our creating alternatives to just a straight expulsion, kind of a pushing through to a different pipe in our system. I think that's where at least I have lots of interest in continuing to think creatively about those solutions that do both.
Director Flores.
So this is a lot of information, but thank you. This is something we needed to have. And this is more to our staff, I think, for the district. In terms of suspended expulsions, the board may, it says here, it may expunge the record, right?
Yes.
So, I've been in the education system for a while, over 20 years. And what I've noticed is that certain types of students or demographics with the ability to pay for, lawyers are able to do just that, right? And they're able to expunge their records. So what I want to know here in this district is how many, suspended expulsions have we actually expunged? Or, in the last, let's say 5 years, for example.
Oh, sorry.
And then, yes, and then out of those, how many of those had actual representation, legal representation? And then I would like to know an analysis of, ethnic breakdown in terms of the expulsion, the suspended expulsion being expunged. So thank you.
I will note the request and follow up when we're done with that data gathering.
And then I would like my peers, to consider maybe adopting a policy where we, as default, we expunge those, as a way to make sure that students have the ability to start anew, and not let these sort of suspended expulsions be in their records, right? So I don't know how the rest of you feel, but I think that's something that we can take a look at as a restorative sort of practice to make sure that, hey, you did messed up once, but we're with you. We want to make sure that you don't do it again, and you have a clean path to adulthood.
Any other questions or discussion on the topic at hand? Yeah, Director Bowie.
And then just to add on with Director Flores, I really like that idea. I feel like everyone should deserve a second chance. And I feel like as teenagers, it's really easy to just have a fixed mindset where like once you mess up, you feel like there's no more opportunity. So being able to like let them know like, hey, like you still can do it. Like I think that's a good mindset.
Okay, I think we're ready to switch gears. Again, I just want to make sure that if we need a 1-minute break, that we have that to help us switch gears if we need it. Okay, we're going to take a 1-minute break. I'll see you in 60 seconds.
right? Okay, so the qualifying reason for just cause includes childcare, needs of child, parent, grandparent. I mean, it's a whole statutory, and I'll read it. Child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. It's either childcare or taking care of them that would require the member to participate remotely, or a contagious illness, or a need related to a defined physical or mental disability that is not somehow accommodated for otherwise. And 4, traveling while on official business of either the board or other state or local agency. Now, I want to point out there, if there is somebody who works for the federal government, their travel is not cause for being able to participate remotely. It's only if you are traveling and you are traveling as a member of this board, or you are with the state or local agency. So I want to be very clear about that. This would be the qualifying reason for asking or invoking the just cause exception. Yes.
Just 2 questions on this slide. Does a board member have to provide proof of 1 through 3? Proof that you're caregiving, proof of an illness, proof of having a physical or mental disability?
So I would say that there is no documentation required, in the sense that you need to bring a doctor's note or some kind of a notification that you're traveling out of state. There is a statement that the board member will have to make publicly that is going to be attached to the agenda. So that would be the personal statement made by the board member, but there is no verifying need of documentation required under the new law.
And my second question, what does another state or local agency mean? What might that look
So
like?
state, we understand, local agency could be the city, the county, working for a special district, working for another school district, working for the county office of education. So those would be state and local agencies. Fire department, police department, those are local agencies. Unfortunately, if you are in private business, it does not provide you the exception. It is only if you are either working on the official business of the school board, or if you're employed by another state, California, state of California, or a local entity, local agency. Thank you. Public agency. Okay, let's move on to the next one. So here is, so if you're going to use the just cause, that is those 4 reasons that we talked about, you must notify the board at the earliest opportunity. So this is where, under governance, in most districts, if there are issues to be communicated, they generally are communicated to the board president. So either you probably have a communication policy in your bylaws, how you communicate with each other, or it may be a good idea to set up a structure by which, and I'm just going to perhaps pick on you and say, if you're going to be out, you would call the board president and say, I am going to be out, I'm giving you notice, it's 2 weeks out, but I just want to give you notice. The other thing that it creates an affirmative obligation for the district to do is track how many people are going to actually be physically present. These were things that we never tracked before, but in order to have a quorum of the majority present, you need to be able to know whether 5 of the 7 board members are actually going to be present at the board meeting. So one of the things that may be wise to do is have some kind of notification to the either board president, or set up a process internally where there is a member of the staff who's notified ahead of time if you're planning not to be present at that board meeting in person, because the other thing we have to track is to make sure that we have enough capacity to hold the meeting in person. So there is that. And then this is the question that you asked, Madam President, which is providing a general description of the circumstances, which would outline the need as to why you need to appear remotely. Again, it doesn't have to be a detailed reason. You're not divulging any diagnosis or confidential information. I would just say invoking just cause, section 1, taking care of taking care of family member as outlined in particular code section. It could be something as simple as that. And you can only use the just cause exception for 2 times in calendar year. So 2 times you have, and I calculated, you have 20 board meetings in a given school year. So you can utilize this twice in a calendar year. Yes.
So does this only apply to regular board meetings or special board meetings treated different?
Really good question. There is not a distinction made. So the way I would read it is that it applies to all Brown Act meetings because they are covered. This is under the current scheme of how you agendize a meeting. So it would apply equally to both special as well as for regularly scheduled board meetings. So if you have 21, say, taking this meeting into consideration, you could only use it for 2 in the whole scheme of the calendar year.
And just because I wasn't clear on this, is this now requiring all school boards to meet hybrid, or is this only for school boards that choose to meet hybrid?
Good question. It's not requiring all school boards to be hybrid. You can utilize the original Brown Act. So AB 361 is going to be gone, right? Which allowed all of the board members to be able to join in remotely. That is going to sunset because there is no emergency currently existing after February 28th of this month. So if you choose not to utilize this, then we go under the old Brown Act methodology, which would be that if you are not going to be present in person, you would actually have to identify where you are going to be. So if one is in, say, New York, at a hotel, you would actually identify the name of the hotel, the address of the hotel, the room number of the hotel, and basically you would have to leave your hotel door in New York City open. And should a member of the public want to come in, sit down and hear as to what's happening in the meeting, they can do that. It's the old teleconference. It is the old teleconference exception. And again, it was written in the 60s and 70s and hasn't caught up with new technology, but that would be the other option available to the board if you do not want to go under 2449.
And the other question is, if, let's say, so the board has to vote at the beginning of the meeting, and if, let's say the board denies it, or a board member has had like their 2 meetings, are they, well, in the case that the board denies it, are they no longer able to participate in the meeting? Can they not be present, like online?
Really?
Can they not vote?
Really good question. I'm going to get to that. But with just cause, the just cause piece, it's a notification. It is not board action. The board doesn't have to accept it. The accepting of the board comes in when you're asking for an emergency circumstance. With just cause, you get to say, I'm not going to be here. This is my just cause. Put it on the board agenda. If the board were to adopt 2449 regulations, you just get to assert what your reasoning is and that you're invoking just cause. But if we go into the next slide, Anna. Yes, please. Sorry, let's go back.
Namira, you just mentioned that it needs to be agendized. So if there is an absence, it needs to be on the board agenda. Is that what I'm hearing?
Correct.
Got it. How long of a notice do you need to make sure it's on the agenda? Because I know the agenda goes live like.
So 72 hours.
So
is
72, oh, okay.
72 hours prior to the board meeting.
Okay.
And if you are a district that has a practice of perhaps publishing your agenda ahead of time, maybe you have 72 hours plus 1 more day because you want to sunshine it to the public sooner, you can do that, but you can modify the agenda up to 72 hours advance of the board meeting to show that a board member is not going to be present because it's going to be just cause.
And if that doesn't happen, then the board member has to be there?
If that doesn't happen, then we treat it as if the board member is not there. I mean, if you cannot be there, you cannot be there. and I think every district will have to also adopt bylaws as to how many absences can a board member have, because, you know, there are going to be, the law is going to limit it to X amount of remote appearances. But what happens when you can't appear at all? So if you cannot be there, then it's going to be an absence. But if you have not agendized it, if you have not notified them, and it's not an emergency exception, then you can be part of the board meeting as a member of the public, but you cannot participate in it.
Thank you.
Okay, any other questions? All right, so let's go on to the emergency circumstances. Now, this is, we get this. This is where you've got a physical, family, or personal medical emergency. And this requires the board member telling the board ahead of time as soon as possible, but it can be as late as the beginning of the board meeting. And it doesn't have to be agendized, right? So the board president will say, and Director Flores, I'm going to just sort of utilize you. Madam President is going to say, Director Flores has just informed me that he will be joining remotely, or is going to be present on a hybrid platform because of emergency circumstances. The board will have to vote on whether or not to accept that emergency circumstance. If they say yes, you are then on Zoom or Teams or whatever your hyperlink, whatever your platform is, and you're participating in the board meeting. If the board were to vote no, then you cannot participate as a board member. You would be watching the board meeting as a member of the public. This also requires you not only just saying that you want to have a remote access based upon emergency circumstances, but you've got to also provide a general description. And the statute actually says not to exceed 20 words. You don't need to include any diagnosis or anything like that. But you have to give more of an explanation. So the board president would actually say, I was notified by Director Flores that he is invoking the emergency circumstance of AB 2449. He's got a personal medical injury. Can I have a board vote on whether or not we accept Director Evers' petition for emergency circumstance and hence remote participation, and the board will vote yea or nay. I saw some hand up.
Director
Yes.
Medina.
Yeah, so you just said that the board member would have to participate as a member of the public. So the law completely bars them from like participating and having this being part of discussion.
They can give public comment.
Well, only in that context. So you just can't be a part of it at all. The law specifically says that.
The law clearly states, I will, can we go to the next slide, please? So first of all, if you're going to be remote, you have to participate both by audio and visual. So there is that. And I'll come back to your question, Board Member Medina. Can you go to the next slide, Anna, and I'll come back this way. Maybe one more, I'm sorry. It clearly states, maybe it's not in this, but yes, the law is very clear that if we don't meet the criteria of what is in the statute, or if the board says that, no, we are not going to accept this as an emergency circumstance rationale, then you cannot participate as a board member. You will be participating as a member of the public. That's in the statute. So in many ways, sometimes it is better to have the old notice requirements, but the problem with that is the old teleconference requirements under the old Brown Act, where you are saying, because there is no permission required per se, but the problem with that is there is there is only oral participation. It's teleconferencing. There is no space for video. I mean, you can actually utilize Zoom. I mean, I think that would be a technological update. I would say it's not contemplated under the law, but it was an old teleconference requirement that the Brown Act had. But it would certainly give you more options. It would give a board member more options under the old scheme.
Superintendent.
Just a question about closed session.
Mhm.
So the cadence of our meetings are that the board president opens the closed session for public comment,
Mhm.
and then we go into closed session. Does this mean that, and then we have public meeting after that?
Correct.
So in order for the board member to participate in closed, technically all of the board has to be seated with that discussion if the board member is going to be remote on an emergency circumstance. Is that correct?
Correct. So
Okay.
you cannot circumvent the intent of 2449 for purposes of holding a closed session. You have to have enough board members to have a quorum, to have a meeting. You have to take a vote on whether or not the emergency circumstance is justified.
Mhm.
And then yea or nay, based upon the number of people present and what the board votes, that's how board members can participate in closed session. Otherwise, it's no different than me as a member of the public trying to get in on a closed session. The other thing, as with all new laws, just to be aware, agencies are going to be looking very hard whether or not boards are complying with the requirements of the law. So we just have to be very meticulous in our note keeping around who's present, who's not present. Frankly, it's not going to be a privileged document. So I also want to put it out there that that document of who's going to be able to attend and who's not is going to be a public record. So record keeping is going to become very important as well.
On that note, are we able to take these votes? Sorry, I guess my question is, it's around the agenda. Like, do we have to agendize these votes for purpose of record keeping? Like, do we have to have, for example, if someone lets us know that, way advance of 72 hours, they have a just cause for joining us remotely, does that have to be an agendized item?
So it would be agendized in the sense that it would be where the board member is going to join us from. Director Evers will be available remotely as they are exercising the just cause option under AB 2449. If Director Evers wants to use the emergency exception, and if he's given you notice before the agenda has been finalized, it needs to be agendized. But if there are going to be circumstances where he may not be able to give you notice, then no notice is required. That is the first order of the business before the board moves on. The law clearly states that that is one of those things that you can actually take a vote on in open session without having it on the agenda if you're talking about emergency circumstances.
And that would include close, like with not thinking about the emergency circumstances, but something that's given to us in advance. And like if we want them to join closed session, that would have to be agendized in closed session as well.
Well, theoretically, a closed session doesn't exist outside a formal meeting. So you have to open the meeting. And before you go into closed session, you've opened the meeting, you take public comment, and then go into closed session. So before going into closed session, you have to make the threshold determination whether or not you have enough people in the building locally present, and or if there is a board member joining remotely, whether or not it's an emergency circumstance or is it a just cause. And if it's emergency, whether or not the board approves that to be an emergency circumstance for that board member to join remotely. So that is when you'll vote. Once you vote and the board member is accepted as participating based upon an emergency circumstance, then the board member can go with the rest of the board that's physically present into closed session via a Zoom platform.
And how formal does the vote have to be?
How what?
How formal? Like, can it be like
It
a
it would
text
have to be
message?
a roll call vote.
It would have to be a roll
Yes.
call vote. Okay.
So usually you're the only one who opens it up, right? So
Right.
that means that we all have to be present
To vote.
to vote.
Yeah, I'm trying to think through these
Right.
logistics.
Me
Yeah, thank
too.
you.
Yeah, okay.
And listen, I mean, when an emergency circumstance would arise, I would think that we would set up a process internally of communication, whether you can let the superintendent know so that there is a communication sent out saying that we will have a vote before we go into closed session. Therefore, we are requesting the presence of all the board members by X time. I would not encourage board members to communicate with each other because that can lead to Brown Act violations. But to the extent that you want to have a notification process, I would use the superintendent's office to push that notification out so that every board member is in the loop around what's happening before going into closed session.
Just to be clear, it's not necessarily just an emergency circumstance. There could be a last minute just cause circumstance, correct? If I'm reading this correctly, the member must notify the legislative body at the earliest possible opportunity, including at the start of a meeting, of their need to participate remotely. And that's under just cause.
So here's the thing, with just cause, it's notification. And so the board member can say that I'm joining remotely. It would be ideal to have that on the agenda, but things can happen.
Exactly.
So that is fine, but that's not a vote. That's just notification.
That's just no, okay. Got it.
Yeah, that's just notification.
And the board member that's meeting that vote is not allowed to vote, right?
That's a good question. Yes, I would say it would be a majority vote of the other of the folks present to determine whether or not that would be an acceptable item for purposes of a emergency circumstance.
If there are more than 2 board members who are exercising emergency circumstance, does that have an impact? You were saying something at the beginning, I think it was with the just cause that you had to have at least 5 out of 7. And so I'm just,
The same applies here. You've got to have 5 out of 7 physically present. And if you've got 5, people can be remote.
quorum is 4, but apparently the statute requires
Sorry,
4.
math. I'm sorry, math challenge. 4 out of 7. I apologize. You said 5, I said 5. Okay. Yes, 4 out of 5, correct. Oh, 4 out of 7. Clearly fractions are not my thing. Yes, 5, it's 4 out of 7, which would be the quorum. Yes, and so 3 could be remote. I'm sorry. Oh, okay. Anna, could you move on to the next slide? The other piece, I think, that you also have to say is that you would have to make a self-attestation if you're joining remotely. You would have to say if any other individual 18 or older is present in the room with you. That would be part of the self-attestation. So you would say, Director Flores, I'm taking care of my mother, and there is no one in this room with me as I join this board meeting, and that if there is a kid or something, I would say there's no one over the age of 18. And if there is somebody over the age of 18, you have to say that they are present there with you. Well, you would have to say any other individuals present and the general nature of any member's relationship with such individuals. So you're not identifying the people, but what you're saying is, this is my neighbor, or this is my, I don't know, it's my daughter's tutor that's just happened to be in the living room as I'm joining it.
La comadre, el compadre. Yeah. All right.
Yes.
True, even if the person who's in the room, like if you're on headphones and they can't see or hear what you're doing.
So under the new law, you cannot be, yes, the answer is yes. And under the new law, you have to be present on video. And I know you were just saying that they can't hear your conversation, but the law does not make any allocations around whether or not you're wearing devices that limit the sound.
And then I heard you kind of follow up with, and then you must be present on camera
Yes,
for the entirety of your time in a
Yes.
virtual presence. Okay.
yes, that is a requirement. Okay, and the other thing is the emergency exceptions cannot be for more than 3 consecutive months or 20% of the regular board meeting within a calendar year. And this talks about regular board meetings. This is the 3 consecutive month rule for emergency exceptions, and that is a 3-month for regular board meetings within a calendar year. Yes.
Sorry, this might be a silly question, but the must participate through both audio and visual technology. So needing to be on the screen the entire time. What if you need to use the restroom? Do you
So-
keep your camera on?
Well, I hope not. No, I think so. Let's use a reasonable standard at that point. I think you put in the chat, be right back, or taking a moment break or whatever, but you have to come back on. The idea is that when the board members are voting, taking action on items that are in the public's domain, that you should be able to see every board member cast their vote. So that is the intent. So yeah, I mean, I think, going and getting a cup of coffee makes, like, just going to your kitchen and getting a cup of coffee. I don't see a problem with that. But I think if the board is actually considering in the midst of a motion, I would not move. It would be like any other regular meeting. You can run to the restroom, but you're not going to do that when a motion has been made and the board is considering the motion. Okay. Can we move on to the next slide? I think the other important piece is the third bullet, which is every board member, every agenda should also indicate how the members of the public can actually access the board. And what I mean by that is their ability to give public comment. That is really critical. And what has been happening in not just school districts, but in certain smaller public agencies in communities that have spotty internet, people have not been able to participate. And the intent of the Brown Act is to hear from your constituents. So that is an important function. So being able to clearly state how they can access to be able to give public comment is a very important piece of the agenda. Anna, may I request to move on to the next slide? Okay. So the two-way audiovisual platform is important. So the Zoom link is that audiovisual platform. And then there is also this movement in certain communities where local boards are saying to members who are joining via technology, via a digital platform, you have to submit your public comments ahead of time so we can read them to you. We can read them to the board. There is no requirement under the law, and this law makes it very clear that you cannot ask a member of public to submit their comments ahead of time. They get to address the board in real time. If they have language issues, you will have a translator present, but this requirement that they have to submit their public comments ahead of time is very clearly not a requirement of the law. So you cannot try to limit public comment in that way. Can I go to the next one? There is one more thing here. This is, I think, a really important piece. When you have disrupted broadcasting procedures, if the broadcasting of the meeting by phone or internet is disrupted, the board is prohibited from taking further action on agenda items until public access is restored. And I mean, makes sense, but there are bodies that engage in gamesmanship, trying to figure out a vote without public pressure. So I want to be very clear. If there is any indication that the technology is not working, the board should not be taking any formal votes. And then any action that may be taken during that disrupted time is subject to a challenge. So a member of the community can say, you violated this particular provision of AB 2449. I want to challenge that. Yes.
So,
Director
So-
Medina, thank you.
One thing that we've had happen in the past that wasn't necessarily a disruption of like the feed, but was we met a limit on the number that can participate. I don't know if that's a problem we might still have, but would that be an issue where they would have to stop?
So are you saying there would be a cap on the number of people who participate? Is that?
Yeah, the early.
In the early Zoom days, we had exceeded 500 people at a meeting. And we didn't know what to do. We did scramble and we did resolve the situation, but.
Yeah, so I would think that one would have to show that they cannot participate. So a Zoom license allows at least 500, 600 people. Okay, so we have 1,000. That would
Hopefully
seem
we won't have
logical,
that.
but I think if there is a need, we upgrade. I mean, that's just the way we go.
But the question is, in that instant, we have to stop voting, stop the meeting until we vote.
So I would think that it has to come to us to know, we should know that it's not working. If there is no indication that it's not working, people are able to comment, people are able to see. I would not say that we stop voting. However, if there is indication on our end that people are unable to join because we don't have enough licenses, or there is some malfunction of technology, you should not take any action. Now, here's the other thing. Just remember, if the action is timely, you need to take it by that night or before the next board meeting or whatever. I think you also have the right to make a decision whether or not you take the action, then cure and correct it later. I mean, because that's the curing and correcting under the Brown Act. But just be aware that if there is a disruption, if people are unable to access, there is the ability to challenge a vote on a particular issue. So, yes.
And the board does have the right to limit the number of minutes on a particular item as well, which is in our policy.
Yeah. So that is a local bylaw issue. That is how you're going to internally handle your meetings. But yeah, yes.
so let's say that we had technological issues and we have a time sensitive sort of vote to do like RIF notices or something like that, that they have to happen by a certain date, right? And our next scheduled board meeting, it's after the fact. So if we schedule a special board meeting, are we allowed to agendize those items that we weren't able to do?
So, so if you're going to talk about layoff notices, they have to be done at a regular board meeting. They cannot be done at a special meeting. So that is going to be a problem. I think timing matters. I think these are things that you have to be very thoughtful about. Reassignments, probe releases, all of these are associated with specific timelines. So that is on the personnel side. On the operations side, when a budget has to be adopted, first interim, all of those are timelines. And so operationally, there has to be a discussion around how we invest in our technological platforms so that the public comment can be supported, so that public input can be supported. And so there might be reasons and options to upgrade. But I also think that one cannot just say that I had disruption of service and therefore the board should not take any action on the certificated layoff notices as part of the March meeting. I think that there has to be evidence of disruption. And those things are very easy to get from Zoom and the platforms that host. So it's not just a anecdotal piece of evidence that I would rely upon. I think the board should take comfort in that. You invest in technology, but then there is the metrics and the data on the back end of the technology that can show who was trying to get in, who was in the waiting room, whether there was an actual disruption, whether there was service outage. All of those are things that we can use to show whether or not a meeting actually was disrupted.
So if we have issues, technological issues per se, with not having people accessing, but I don't know, the technology here breaks down, for example, do we have to stop the meeting at that point?
You are prohibited from taking further action on the agenda. So I would say that even if you're in the information part of the agenda where you're not taking formal action, I would say you would stop and try to restore the technology before moving on. It's not just formal action, but further action on agenda items. I mean, the whole intent is to get, to do the people's business in open, and that is part of the focus of the law.
That's if we choose to do hybrid, right? Because right now this is hybrid, but it's still open to the public, right? So we do have public,
Right.
here.
This is if we go down the path of 2449.
right? And then do we have to vote every 30 days, just like we did with?
So the board can choose to vote one or the other. You can choose to say we are not going to comply with 2449. We are going to stay with the the original Brown Act, and that would be the posting of your location option.
And that needs to be done prior to the meeting. We couldn't just do it here if we started to have technological issues. We're just going to.
No, you have to adopt one or the other.
Okay, got it.
2449 does expire, though. It has a
It does,
26
26.
expiration date. Okay.
Yeah.
And then going back to currently AB 361 expires.
The end of this
Jane,
month. Well, the law expires in 24, but the emergency that allowed us to use the law expires at the end of this month.
Okay, thank you.
Maybe move on to the next slide. Oh, okay, here are the rules. These are all the rules. Effective January 1, 2026, we are going to revert back to the old world of the Brown Act with the notification on the door option, as I call it. So eventually we're going to go back there unless there is an overhaul of the Brown Act to incorporate hybrid technology. So, okay, want to go to the next slide? Oh, do you have a question?
As I'm learning, does that mean no more hybrid? That means in person only?
If we go back to the original Brown Act,
Yes.
yes, there is no provision for hybrid. That's not to say that you can't provide a Zoom link for your members of the community. That does not, I mean, the original Brown Act never had any language around it, so you could still have that, but you would not be limited by no action because there would be a disruption of technology.
So the board, if they were to choose to vote to move on and utilize under the law of AB 2449, then we would continue hybrid if that was the pleasure of the board. And then if they chose to go back to the Brown Act, they would select that and we would remove the hybrid option.
You could remove the hybrid option. There would be no hybrid option for the board members.
Right.
There would be a teleconference option, which would be, phone and, but that would not preclude you from having a digital option for your members of the community.
Okay.
You could still have that to have public input. What you won't have is that language that is going to say everything shuts down if there is a disruption of technology. Because that is only in 2449.
Thank you.
Okay, last slide, Anna, is there anything else? Okay, this is the practical consideration. I do think we have to set up some kind of a process by which board members communicate. And I will also say this, please do not make it a Google Doc, because I do believe that Google Docs have problems in terms of having more than 3 board members on the same document at the same time, or 4 board members at the same time can create a meeting. So please utilize district staff to sort of keep record of who's going to be there, what is a just cause, what is an emergency exception. And again, a public record, members from the community can ask for it. I do want to point out the last pieces. You've got to, for virtual attendance, you must have justification for just cause or a request for board action, although the law just says that if the emergency happens after the agenda has printed, it doesn't need to be on the agenda. You can come in to the meeting and take a vote. You have to talk about the public affirmation, whether anybody who's over the age of 18 is present in the room at the remote location, and the nature of your relationship. And a statement by the member that they will participate with both audio and video capabilities throughout the meeting. I mean, those are the 3 self-affirmations, and we can have that available for every board member. It could be, just a little card that is available so you can read that.
So just thinking out loud, we have a board meeting on February 22nd. And then our next board meeting is March 8th. So my plan is to bring forward some information to the board to consider on February 22nd, to what stance the board wants to take, either or, so that on March 8th, technically March 1st, that new rule applies. So rules apply starting March 8th and forward.
Okay, so a couple things. First, I'm looking here at the definition of teleconference in the government code, and it says a meeting of the legislative body where the members of which are in different locations connected by electronic means through either audio or video or both. And so in the I think it's 54953, the old code, it's teleconferencing. So does that have a different definition?
No,
Or is it the same?
it's been updated to include, so in the olden days, it was just a straight up teleconference, right? Telephone call. But now the language has been updated to include audio, video, or both. So if you are, and I'll just use an example, I had a board member join a board meeting the other day from Ghana. Her video feed was not working. So if we had 2449, you had to be present with both audio and video. It would not work. But if we were under the old Brown Act rules, because she was on her audio was working, it would be completely permissible under the definition of teleconference, as you just read, under the original Brown Act. So they've updated that language.
And the old teleconferencing rules don't prohibit us from doing what we do now, right? It's kind of the same thing.
Yes.
This hybrid model. It seems like that's more or less restrictive, aside from the posting of the locations and being accessible to the public. Would you agree?
Yes, it does not prohibit you from having a hybrid for purposes of your community. You can still, because it gives you the option of both audio and video, you can still use a Zoom link because it meets the requirement, and it does not hamper you with the language around what happens when there is disruption of technology.
And in reading the code, it also talks about when teleconferencing, all votes must be roll call. So I'm looking at something like when we vote to extend the meeting, and sometimes we just have everybody that agrees vote. Every single vote would have to be roll call, or is only like primary motions or?
I think everything, any formal action should be a roll call vote. I mean, that is just the best practice for purposes of keeping records, for purposes of your minutes, for purposes of making sure that everybody's engaged, and for purposes of public accountability. It should be a roll call vote. Unless, shall we take a 5-minute break? I mean, that doesn't need to be a roll call vote. But I think on issues of substance, including whether or not you're going to extend the meeting and maybe, or not have the meeting extended, so that an issue that is perhaps of value to certain members of the community, they have to come down to the next session, I think should be a roll call vote. So good practice requires roll call votes, and teleconference or Zoom should not matter on that. Okay, I wanted to highlight this. I know we are, it's almost 8:30. This is the administrative support and record keeping that I have kept. I have a slide, and I can certainly work with the superintendent and the superintendent's office to create some kind of a form that could be sort of distributed to maintain those records. But that's all I have on AB 2449. I am happy to take any other questions if you have.
Yeah, I just wanted to be clear on one other thing. I think the AB 2449 has the restriction on quorum. The quorum has to be within the physical location versus the other one.
No, the other one has jurisdiction.
Well, the other one has to be, but they have to be within the jurisdiction. It's not based on a physical location. They could be teleconferencing from within the jurisdiction physically in like the location where the meeting's taking place, correct?
No, so you were talking about the original Brown Act rules around teleconferencing?
Yeah, 54953.
Yeah, so the best practice with respect to the original Brown Act is that people show up at one physical location with members who are going to be on teleconferencing in.
Yeah, but the quorum requirement, they have to be like, you could be teleconferencing from your house and still meet the quorum requirement.
I would have to check that. I don't think it's that open. I think a quorum still needs to be physically present in a physical location. I think that's the fundamental view of the original Brown Act, that people are together, and then there are people who will peel off to have teleconferencing options, but not that everybody can teleconference.
Here it is. It says during the teleconference, at least the quorum of the members of the legislative body shall participate from locations within the boundaries of the territory over which the local agency exercises jurisdiction.
But that is, I need to pull it up. So can I circle back on that question with you? I need to just look at the law really quickly.
Yeah, I think it's fine. I just want to be clear.
Yeah, no, I get it. That's a really good question. No,
Code section off the top of your head.
no, it's 50, just add. Yeah, there you go. There you go. Yeah. Sorry, I'm just I'm sorry, I'm looking at it.
And I have a question for you.
Yeah, please.
No, to staff, I don't know, superintendent. In terms of, Namita mentioned that she'll work with you in terms of next steps or having a cheat sheet of some sort, but that will happen after we take the vote, right?
Yes. Okay, can I get back to you on that? Trustee, I need to find this. I need my handy dandy marked Brown Act sheet. Okay. Are there any other questions?
I have a question.
Yeah.
With AB 361, we were taking action at board meetings to continue to use or operate under AB 361. Do we have to do something similar with AB 2449?
No, I think the timeline is that the board will discuss this at your next session. And then the board will vote one way or the other. And then it's not like you take that vote every month. There is no requirement of a monthly action by the board. It's going to be standing for a couple of years till the board makes change. Oh, battery's running low. Sorry, the battery is running low here. Yeah. Any other questions? Yeah, please.
Well, while he's thinking, just to reiterate, to make sure I understand this, it sounds like the traditional Brown Act rules are less restrictive in terms of what we can do, right? And the only changes will be, the ability for us to zoom in, but that does not negate the fact that the public will be able to zoom in. Correct?
Yeah, but you can make the public zoom in if you
Right,
so choose.
so that's also, okay, that's what Superintendent Trinnell mentioned. Okay. So I'm having a hard time understanding why we have AB 2449 now with so many restrictions when we can still do the traditional Brown Act with less restrictions and still be able to Zoom.
Well, so the original Brown Act did not envision the Zoom technology, so that exists today. It also takes care of the exigent circumstances, emergency circumstances, where you can come up at the last minute and say, hey, I need to be able to join this meeting. I thought I was going to make it, but I can't. Under the original scheme, if you don't show up, you don't show up. And if you're not on the agenda, you're excluded. But under the new scheme, to incorporate people's lives, whether it's taking care of your family, whether it's the pandemic, it just gives you more options.
It sounds, it also sounds like it protects the board members a little bit too, like under the regular Brown Act. To me, I understand that you would have to post your location and where
Yes.
you're at, and under AB 2449, you don't have to do that. You only post the location of where the physical quorum is conducting business. So to me, it also sounds like it protects the board members a little bit more.
And that's a really good point. If you're if you are in a hotel room, having strangers come into your hotel room is problematic. So.
Under board bylaw 9320, under teleconferencing, it says a teleconference is a meeting of the board in which board members are in different locations connected by electronic means through audio and or video. The board may use teleconferences for all purposes in connection with any meeting within the board's subject matter jurisdiction. All votes taken during a teleconference meeting shall be by roll call. During the teleconference, at least a quorum of the members of the board shall participate from locations within district boundaries. Agendas shall be posted at all of those teleconferencing locations. and basically allow for members of the public to go into your home or your hotel room or wherever you are at, et cetera, et cetera.
Yes, so I would, trustee Medina, I would defer to this particular bylaw that she just said to validate your point that it would be within the jurisdiction, but it would be open to your homes or wherever you're going to be, and most people prefer a central location.
Posting those locations publicly on the agenda.
I guess the question that I have now is, I'm trying to find where it says we have to choose either or. Like, I'm wondering, like, can you, like, if you don't want to post your location, you do AB 2449, or if you're going to be doing something else, you post your location. Like, I
That would
don't
be
think.
under AB 2449.
Do you know where in government code that is? That's what I'm trying to find.
It's under the, oh, this is the legislative. It's under 54953. Foundation just cause. Yeah, it's 54953 and so you would have to choose and this one says at least a quorum of, yeah, it's
So to understand your question, trustee Medina, and please don't make me talk about the Brown Act. That's like just to understand your question, are you asking whether the board can at each meeting or every 3 months change from one to the other?
I'm just asking, I'm trying to see, I'm looking at 54953 and where it says you have to choose AB 2449 or you have to use the old teleconference. Because when I'm looking at 54953, I'm seeing the old teleconference stuff. So I'm not saying anything that says we have to do one or the other. We can't do both.
Oh, so I think the question, and maybe Namita can back me up, or the answer is that the provisions can't exist together. You can't have a blended meeting where you do both traditional teleconferencing and AB 2449 hybrid participation. So in essence, you have to hold your meeting under one scheme or the other. There's no way to, it's not that both schemes exist at the same time, if I'm understanding your question correctly.
I hear what you're saying, but I don't see why not. I mean, I see it could happen, but I also don't see here where it says that you
So-
can't. Like either you disclose your location or you have the option to not disclose your location if these.
actually,
requirements
I was
are-
reading the Leg Info digest and it said, my computer died. It just said, it gives, I'll send you that particular provision in the law, but it said it gives the board the option to use this until January 1, 2026 as part of teleconference options. And then it lays out all of the new laws of 2449 if you're using teleconference in that sense. So
So as an option, as an additional option?
no, as in one or the other. You can't have the Brown Act teleconference of the old with the blended of the new. It has to be one or the other.
Yeah, trustee Medina, the language is the bill would revise and recast teleconferencing provisions and until January 1st, 2026 would authorize a local agency to use teleconferencing without complying with the teleconferencing requirements that each teleconference location be identified. Under this exception, the bill would authorize a member of the public to participate remotely, et cetera, et cetera. It is an exception to the traditional Brown Act requirements. So because it's an exception, you have to either take it as a whole, as an exception, or not take it as a whole and then use the former requirements.
And I was just going to say, I think the backdrop here is that this is part of California's open government laws and is designed to create transparency and kind of consistency for the public in order to facilitate their participation and expectations for what to expect from us, right? So I think it's not picking and choosing what we're going to do on any one day, but to say, these are the rules and here's how you can expect to see us show up or not.
Any other questions? Okay.
Here is mud.
No, it's
No,
clear as
it's
mud.
And again, if there are any further questions, feel free to reach out, but I just wanted to highlight that particular provision because it is new and boards are trying to figure out how to navigate it.
So, so this is gonna come back to us as a discussion and action item at the same time, and will they be here to answer any questions? Okay.
I'm happy to be.
I'm gonna be no use to you.
Well, Namita be here. Just in case, you know, because I think we've asked quite a few questions. I think I'm clear as to, you know, where I'm leaning, but I don't know if after, you know, I might get some emails and, you know, members from the public's opinion. But it will be nice to have someone who can answer questions then if we have any, so.
Okay, I have another. So in AB 2449, past the to just cause situations or whatever limit there is, or if the board chooses not to accept, that member cannot participate at all in the meeting, even if that member is available to participate versus teleconferencing, versus the old version, they'd be able to participate because they're available.
They would be able to participate if agendized properly. Yes.
Any more questions? Okay. Thank you, David. Thank you, Namita.
My pleasure, our pleasure.
Yes.
Thank you. Do we have more? Okay. Well, before we adjourn today's meeting, Superintendent Trinnell, are there any last announcements?
Thank you, everyone. Thank you to our guests this evening and for all of your expertise in navigating the language with us. And Namita, I will follow up with you about February 22nd. No school this coming Monday. So just a reminder, it's a holiday. And I hope everyone has a good evening.
Meeting adjourned.